be looking for my assistants who handle the collections, saying that they want to thank them for being so kind. And so we try to do that, even though it does take more of my staff's time, and even though it does, leave them sometimes open for people to be a little nasty. We try to do what we can to work with them because they are your neighbors. So I find that to be important. I think another thing that's important to an association is knowing the costs of the collections. When my firm handles the collections, when we send a demand letter, an estoppel letter, a lien, notice of intent to foreclose on that lien, we bill the unit owner for that, not the association. It's put right into the letter that's sent to the owner. Or if it's a payoff letter for a bank, write in the letter to the bank. And so until there comes a point where either a lender's foreclosing, or the association is foreclosing, or there's a bankruptcy, we don't bill the association, we bill the owner. We also don't move forward with liens or foreclosures until we get a written authorization from the board to make sure there's no misunderstandings. I've had clients come to me and say they left counsel because somebody they were trying to work with had a lawsuit filed against them and thousands of dollars in fees, and it turned out that the lawyer wrote a letter and it got misplaced or it didn't make it to the right person, and the letter said, "Unless we hear from you otherwise, we presume that you would want us to file this foreclosure action. So if we don't hear from you within a week, we will file." And then they file, and then it turns out that you didn't want it filed. And I find that's even more of a big issue now, because now we need to really look on when someone should have it filed, and I'd have to find out about how you have things worked out here, whether you have rentals or not, because there's different things that can be done now to try to assist in collections without just foreclosing. Maybe there's a tenant in there and you can require that the tenant's rent be paid directly to the association, or they be removed, or go to court and ask the judge to appoint the association as a receiver, or to put the money in the registry for the tenant, so that you can be collecting that money rather than foreclosing on an owner who's about to be foreclosed by a bank. It's really a decision that needs to be made case by case and at the right time. Sometimes it's a timing factor. So I find that at this point, rather than your typical letter which says, do you want to foreclose, I've now been having to talk to the associations about the factors. How much do they owe? Is the bank about to foreclose? Is there a tenant involved? Not to not take legal action against someone who's not paying, but to see which is the best method first at that point. So we try to, handle things more on a case by case. And maybe it's because I am a smaller firm that we can do that, and that's the way I've set things up. I don't have it set up like a mill. But my feeling is that I want to try to help you do what's best for the association. Unfortunately, sometimes there is no best. Fortunately, sometimes what you need to do is you need to foreclose, because what's happening is the unit owner may not be paying you, but they're paying their lender, or the lender's just not doing anything about the fact that they're not getting paid. A lot of the lenders right now are stalling on all their foreclosures. So sometimes you have to do it, because if you don't pursue them, then they're going to say, well, why should I ever pay? So sometimes you have no choice but to do that, because we've tried to work it out with them. They haven't made the payment arrangements. We've tried to be considerate. The owner's living there, it's not a tenant, and the mortgage company is not going forward, and then in that place we need to do something. So unfortunately it's a necessary evil, because otherwise it becomes a domino effect. So you do end up having to spend some money in order to avoid that domino effect. But as I said, it's not until we file the foreclosure action that I then start billing the association, or if the lender files. So in that way, if it comes to a question, should we or shouldn't we file the lien? Well, in that respect, so long as the lender doesn't foreclose and you end up with an inability to collect, it's not a big deal for the association for me to file the lien, because I'm not charging the association, I'm charging the unit owner. And whatever policies you want is what I handle for each association is different. I have some clients that they would prefer that all the monies come through my trust account. Even if you receive it, they send me the checks, I deposit it with a power of attorney. Other clients are just fine when I tell them, as As long as you tell me about the check, send me a copy of it, I'll tell you to deposit it. A lot of lawyers don't do that. They tell you send all the money to them. They sit on it for a year, 2 years in their trust account, and in the meantime, you have nothing. And I understand their reasoning for it, but my concerns are that in the meantime, all the interest that's accruing on those monies are not going to me, they're not going to you, they're going to the state. So I'd prefer the monies go to you. So if you receive monies, if my fees need to be paid out of them because my fees do get paid before the maintenance, I'll say, fine, just take the money, I'll send you the bill. Or some clients would say, well, as long as you still haven't been paid, I'll send you the first check, but then after that, we'll keep the other ones. And then as long as we have a line of communication open, and it's clear when you get payments so I don't file liens wrongfully and have the wrong figures, as long as we have that open line, I'd rather you have the money. Even if you send me the money and I run it through my trust account, it could take a month before you get it to me, I deposit it, then I have to wait for it to clear, and because it's a trust account, I have to wait those full 10 business days from when it gets deposited, and then I cut the check, and then I send it back to you, and I may not cut the check the very next day, maybe I'm cutting checks only once that week. And by the time you get the money back, it's been a month. So my feeling is that for clients who are okay with it, I work it out with them where they can hang on to the money, and if I have the money, although I may not cut the money every single time I get a payment, if someone's paying a couple $100 at a time, I might not cut you a check every couple of weeks. But if I have, someone makes a $1,000 payment, when that clears, I'm going to send that on. I just feel that even though it's extra work for my office, I'd rather the money be in your account. If there were to ever be a question later about whether the unit owner overpaid, it could still be returned, whether it's in my office or in your account. If there's an issue ever of someone claiming that there's been some sort of settlement discussions with my office, I may not even want to cash the check at all, much less put it in my account. But frankly, I think because of the statute, it can be cashed. And so in those cases, I might just say, let me hang on to it for right now. But for the most part, I don't hang on to monies for long term. As I said, it does cause me extra work. In terms of not even just the idea of cutting the checks, but keeping track of how much money that you've been paid, because it makes the accounting very complicated. Your ledger gets more complicated, but we've accounted for that in my office, and we deal with that. And I think that particularly in this economy, it's important for associations to not wait until someone's done paying when they're taking 6 months or a year to pay, for you to collect your money when it's just sitting in my account, not collecting any interest for you. So in any case, that's how I handle collections. I don't know if you all have any questions about that, but I figure we should deal with that before we move on to any other issues.
I have a question. How are you billing the unit owners for your service if they're not paying their maintenance? How are they going to pay your fees?
Because typically, when they're not paying their maintenance, it's because they're trying to maybe borrow from Peter to pay Paul, or whatever the case may be. But when they start getting letters from a lawyer, all of a sudden they start paying.
So that's not the case.
And if it's not the case, then we file the lien and we try to get it from that. If that's not the case, then we go to foreclose. Now, if it turns out that we're unable to get the money from the owner because they're just not going to pay because they're giving up their place to the lender, well, we do our best to collect as much as possible from the lender. And that gets real complicated, and if I were to be your counsel, we would discuss all the issues of when the lender has to pay and when they don't have to pay, but there are arguments that they have to pay legal fees, that legal fees are not mentioned in the statute. So, we try to make all, the arguments by law that we can with the lender to make the lender have to pay whatever has not been paid by an owner. Typically, and as I said, even though I said once the lender files foreclosure, I bill the association. Although I've been billing the association for dealing with answering the foreclosure, typically I have not been sending a bill for demand letters that I had already issued at that point. I wait it out and see whether we're able to collect it. And as I said, I have some where we've actually been successful with renting the units too. Very often the unit is vacant, the owner is not living there but is around, can be found, and a deal is made with the owner to put a tenant in there. and the association gets paid until the delinquency's caught up. And then after that,